everybody, and welcome to the Alex Cuesta Daily Show. How is everybody on this Thursday, May 5th of 2022? I hope all is well. Hope everybody is doing well, is happy, is healthy, is good. And thank you for choosing to join me to listen to this show. If you like what you hear, like, share, follow, subscribe, rate 5 stars on Spotify and iTunes, spread this word of mouth, and go find us on socials, The Alex Cuesta Show. Go search it. We should be there. Now, I have to say that yesterday, I am officially a bad Star Wars fan. How did I miss May the 4th be with you? Maybe it's because I was on with David, and David's not the biggest Star Wars fan, but I have become a massive Star Wars nerd. And anyone that knows me knows it's not surprising that I'm being a nerd, but I have been reading upon reading upon reading. And when I say reading, I mean using the Libby app to do audiobooks, because I read slow as shit and listening's a lot easier to me. So, I listen to a lot of books, but I've been listening to a ton of Star Wars for the past few years now, just going through the expanded universe, whether it's the Legends version, which Disney has canceled, which has an insane amount of good work, or whether it's a new canon version that Disney has basically given its good graces saying it's real. But regardless, I've ingested so much. So for me to miss May the 4th be with you makes me a bad Star Wars fan, but I'm going to make up for it because I'm going to say to everybody, today is Revenge of the 5th. So there we go. For those of you that don't know where that reference is, kick rocks, go watch some Star Wars. So let's get right down into it, because today I think is a important episode. I've done some important episodes already before, but I think today is very important for currently what's going on in the current climate. I'll explain more after we get through the Biden COVID tracker, because yes, here we are here still. And it's things are going on. And the man needs to be held accountable. The man with no plan, Joe Biden, needs to be held accountable for what he is doing here. So let's do. Yesterday on the 4th of May, we were at 81,476,300 cases. And in terms of deaths, we were at 994,639. As of today, May 5th, we are at 81,567,248 cases. That is an uptick of 90,948. In terms of deaths, we are at 995,083. That is an uptick of 444. So what does that say? We have a marginal number of deaths coming up for the second day in a row. Cases closer to 100,000, still nothing to call home about. I read an interesting article. I think it was from NPR. I think it might have been NPR, maybe CNN. I think it was NPR. They did an interview, and the title was, what would an endemic look like? And essentially the motherfucker described what's going on right now. And the way he described his definition of it is incorrect. His definition, he said, I've seen it used this way, endemic. It's when essentially when you can predict the pattern and the behavior of the disease. Everywhere I looked up the definition of endemic basically says that it's controlled to a regional area. So maybe that's what he means, but I think he's getting a little bit too cute with it. Essentially, an endemic means that you can keep the disease within your walls. Like maybe coronavirus doesn't count because it keeps on moving around and mutating. But the example I saw used was malaria. Malaria is rampant in certain areas, not rampant in others. It's an endemic in certain areas, not an endemic in others. But however you want to phrase it, we are out of pandemic mode. So whether we're in an endemic or not, we are out of pandemic mode with this. And the reason I keep on doing the COVID tracker is because, like I said, we need to hold Joe Biden accountable. And on top of that, everyone needs to continue to realize every single day is another day that this man abuses his constitutional power, the thing he was sworn to uphold as the president, because what he's doing is extra constitutional with the emergency pandemic powers that he's using. And he shouldn't be doing it anymore. It's done. We're over. That's it. And, every single time we think we're going to give it back, they make an excuse. Oh, we have to see. There maybe is another variant on the way. Oh, we got to wait till the fall to see if there's a bump in the fall. We need to be able to move quickly. And that's the way dictators talk. That's the way authoritarians and dictators talk, where, we need to have the ability to move swiftly on this. So I need to continue to have some extra powers that I don't necessarily have. Just be wary. Be wary of who you support. Be wary of what they support, because this is not good. Speaking of supporting, we're going to get right down into it today because, like I said, I feel like this episode is going to be a very important episode. So I did the episode 2 days ago when I talked about the Politico article that has blown up, has rekindled Roe versus Wade in a very big way. And I kind of read the article, and as I was there, I was on the side of Justice Breyer and his interpretation of why he would side with the Mississippi bill. And I got to thinking, how the hell can people make an informed decision on if Justice Breyer, Justice Alito. What the hell am I saying Justice Breyer for? Justice Alito. Justice Breyer obviously said no, he's a liberal, he's on the left. Justice Alito is more of a constitutionalist. I'm not even going to say he's on the right. He just believes in the Constitution. So Justice Alito was on the side of on the majority on the mock vote. It's not a real vote. It's not a real draft opinion. It's all mock. It's all exercise. But in this opinion, he was stating, and I was mostly on his side for his reasons. But I did get to thinking, we need to know what the Mississippi bill says and what it is. And we cannot keep on leaving all this type of shit up to only the courts or only our government to know what these bills say. Because most of these state bills are not what you think of in the federal government, where they're 1,000-page bills, 2,000-page bills, 600-page bills. Those are unreasonable, but that's not what you get a lot of the times. People recall a little while back, I read the Parental Rights and Education Act from Florida, which was dubbed the Don't Say Gay bill by the activists. And lo and behold, when you read the bill, it's not a bad bill. It has nothing to do with not saying gay, but no one reads it. It's a 6-page bill. Nobody reads it. 7-page bill, whatever. No one reads these bills, and they're readable. Some of the stuff is legal jargon, but they're digestible, and you can get the understanding of what the bill is actually trying to say. And then you can make an informed decision of, oh, that's reasonable, or no, don't do that. And not just sit there and be a rah-rah for your fucking side. Don't automatically go and say, oh, well, potentially bans abortion. I'm pro-choice. I hate this. Or cool, bans abortion. Let me be it. And, not think about any of the nuance or who you are as a person. Just putting yourself in the shoes of being a part of a group and not giving a fuck about what you actually think or trying to make an informed decision. So here I am. I am here yet again to read the bill in its full entirety and try and interpret some of it. Again, I'm not a law guy. I'm not an expert, so don't take my law stuff as it is. There's plenty of law people on YouTube that you could probably go to with this and maybe ask them to do it, and they might be able to give you legal jargon better, but there's not a ton of legal jargon in here. A lot of it's layman terms, so I'm going to try and explain it as best as I can. And let's see where we go from here. I've read it already twice, so I know where I stand, and I'll kind of give you my opinion on the end, where I stand on this legislation and what I think should happen in the Supreme Court with it. But I'll let everyone make their decision. I'll read it out to you and then do something that no one else is doing. Nobody reads these bills. So let's go right here. First off, it is the Mississippi House Bill 1510. It was, I don't think it says who it was introduced. It was introduced by Representatives Curry, Eubanks, Gibson, Ford, Carpenter, Bain, Scoggin, and a bunch of the, I'm not going to go through all of them, a bunch of the Mississippi House members. And it is known as, then let's just start with the bill. Let's just read it here. So House Bill 1510. Let's go. An act to be known as the Gestational Age Act, to enact definitions to prohibit abortions after 15 weeks gestation, to provide civil penalties, and for related purposes. Be it enacted by the legislation of the state of Mississippi. So let's really get into it now. Section 1. This section shall be known and cited as the Gestational Age Act. Legislative findings and purpose. The legislation makes the following findings of fact and incorporates them herein by reference. Now, before I keep going, I'm not going to tell you all the subsections. I'm not going to do all that because it will get confusing, because right from there, it goes right to from section 1 to subsection 1 to subsection A, then down to subsection B, subsection I. I'm not going to do all that. I'm just going to read it. I'm going to make my pauses, and we're just going to go from there. If I have to stop and tell you it's a part of a specific thing or not, I'll let you know. All right, let's keep going here. The United States is one of only 7 nations in the world that permits non-therapeutic or elective abortion on demand after the 20th week of gestation. In fact, Fully 75% of all nations do not permit abortion after 12 weeks gestation, except in most instances to save the life and to preserve the physical health of the mother. So that's interesting. They lead off with that. They're trying to build their case here that United States is unique in their law, that they are way over in terms of the weeks, and that they don't, and just the fact that they're going to 15 weeks is still a leap. 3 weeks after most countries, 75% of nations that allow abortions go around 12 weeks. So it is more than over 75% of the countries that allow abortions. So they're building their case that already that this is a fair number. Let's keep going. Medical and other authorities now know more about human prenatal development than ever before, including that between 5 and 6 weeks gestation, an unborn human being's heart begins beating. An unborn human begins to move about in the womb at approximately 8 weeks gestation. At 9 weeks gestation, all basic physiological functions are present. Teeth and eyes are present, as well as external genitalia. An unborn human being's vital organs begin to function at 10 weeks gestation. Hair, fingernails, and toenails also begin to form. At 11 weeks gestation, an unborn human being's diaphragm is developing, and he or she may even hiccup. He or she is beginning to move about freely in the womb. At 12 weeks gestation, an unborn human being can open and closes his or her fingers, starts to make sucking motions, and senses stimulation from the world outside the womb. Importantly, he or she has taken on the human form in all relevant aspects. Gonzalez versus Carhart. The Supreme Court. All right, so let me stop there. That whole first little spot was to build the fact that anytime before 12 weeks, people like to say, viability starts at 12 weeks. And they mention that the human form is relevant in all aspects. But they're trying to make the case here that as early as 5 weeks, you're starting to see what creates a human occurring. So they're really starting to pull at the notion that even, giving 15 weeks is still an extreme. Within 15 weeks is still an extreme. That's what they're trying to get across here when you read this bill. They're trying to describe to you the human baby in its most basic form. So they're trying to disprove the argument that it's a clump of cells before viability, because right here they're talking about all the things that are developing and all the things that are here. Let's keep going. The Supreme Court has long recognized that the state of Mississippi has an important and legitimate interest in protecting the potentiality of human life. Roe versus Wade, and specifically that the state has an interest in protecting the life of the unborn. Planned Parenthood versus Casey. The majority of abortion procedures performed after 15 weeks gestation are dilation and evacuation procedures, which involve the use of surgical instruments to crush and tear the unborn child apart before removing the pieces of the dead child from the womb. The legislation finds that the intentional commit of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. So they describe one of the most brutal ways that an abortion occurs in this part. The way that they use instruments to tear a baby apart. There is no anesthesia given to the baby, as far as I know. That infant is murdered in a way. I mean, if you don't think that's a baby, I get and that's after 15 weeks too. That's after 15 weeks. So we're talking about 12 weeks. The human form is there. The baby's making a sucking motion. It's opening, closing its hands. 3 weeks later, and then beyond, they're saying this is the majority of the way it's performed. Hearing it described is terrible. They're doing a lot here emotionally. When they talk about the baby. And now in this part, they talk about crush and tear the unborn child apart before removing the pieces of the dead child out the womb. They're having a woman deliver pieces of a baby. That woman's baby is being taken out piece by piece. I mean, they say call it barbaric. Doesn't seem too far off when it's described like that. Let's keep going. Most obstetrics and gynecologists practicing in the state of Mississippi do not offer or perform non-therapeutic or elective abortions. Even fewer offer or perform the dilation and evacuation abortion procedure, even though it is within their scope of practice. Abortion carries significant physical and physiological risks to the maternal patient, and these physical and physiological risks increase with gestational age. Specifically, in abortions performed after 8 weeks gestation, the relative physical and physiological risks escalate exponentially as gestational age increases. L. Barrett, risk factors for legal into the more. Yeah, that was just kind of that was their reference. Sorry, the reference right there. Let me keep going. Importantly, as the second trimester progresses, in the vast majority of uncomplicated pregnancies, the maternal health risks of undergoing an abortion are greater than the risk of carrying the pregnancy to term. So they're making some arguments here. That one, I'm sorry I stumbled on the reference, but they're putting references when they are making statements that seem to need references to back them up, like in terms of when the weeks are. And in this one, they're basically arguing because a lot of the times people are like, the risk of pregnancy is pretty bad too as an abortion. And they're arguing that in a perfectly healthy pregnancy, that is more of a risk of getting an abortion. Don't know the truth of it, but that's what they're arguing. Let's keep going. Medical complications from dilation and evacuation abortions include, but are not limited to, pelvic infection, incomplete abortions, retained tissues, blood clots, heavy bleeding and hemorrhage, laceration, tear, or other injury to the cervix, puncture, laceration, tear, or other injury to the uterus, injury to the bowel or bladder, depression, anxiety, substance abuse, and other emotional or physiological problems. Further, in abortions performed after 15 weeks gestation, there is a higher risk of requiring hysterectomy or other reparative surgery or blood transfusion. So they go over all the risks here, and they're really focusing on dilation and evacuation, which they described up top, and it's the most brutal form. But they're talking about all the risks, and they're putting instruments inside of a woman to go and tear this baby apart, tear it out piece by piece by piece. So the chance of a scratch, a chance of certain of these things occurring does seem like it has a high chance. Now, whether or not they're common, they don't say the most common ones. They just list all of them that happen. And there is a risk there. It's essentially a mini surgery if they get a tear going on there, and they talked about the hysterectomy. So again, they are pulling at the dangers, the risks, the brutality in the first part of this bill here. And I think in the majority of the bill, that's why they are against it. Let's keep going. The state of Mississippi also has legitimate interest from the outset of pregnancy in protecting the health of women, Planned Parenthood versus Casey, as the medical, emotional, and psychological consequences of abortion are serious and can be lasting. Based on the findings in paragraph A of this subsection, it is the intent of the legislature through this act and any regulations and policies promulgated hereunder to restrict the practice of non-therapeutic or elective abortion to the period of up to 15 weeks of gestation. So it's officially in the bill now. That's the number, 15 weeks. And they're essentially saying the practice of non-therapeutic or elective, so that it's not necessary to save the life of the mother, that it doesn't have a medical necessity, is what they're saying with the non-therapeutic or elective abortion. Essentially, I don't want this kid, get it out of me, past 15 weeks. So that's, and again, they reference the number of 12 weeks in 75% of the countries, and that United States is only one of 7 past 20 weeks where you can get an abortion. So they're looking at a number in between the past 20 and 12, and they landed on 15, which 12 to 15, I think, has been argued, maybe 16 weeks of the period of viability. So they're falling right in there. So let's keep going here. Definitions as used in this section. Abortion means the use or prescription of an instrument, medicine, drug, or other substances or device with the intent to terminate a clinically diagnosable pregnancy for reasons other than to increase the probability of a live birth, to preserve the life or health of the unborn human being, to terminate an ectopic pregnancy, or to remove a dead unborn human being. Attempt to perform and induce an abortion means to do or omit anything that, under the circumstance as the person believes them to be, is an act or omission that constitutes a substantial step in a course of conduct planned to accumulate in the performance or induction of an abortion in violation of this section. So let's break down those two. Abortion, I think, is pretty standard. They describe it as using instruments, drugs, medicines to essentially kill the baby that's inside the womb, stop a live birth, terminate it, take it out. Attempt to perform or induce an abortion means that doing anything that is out of the realm of trying to bring a woman to term as a physician. So not not properly getting the checks, not properly doing anything. Like, so it's just essentially, if you've ever been with your wife that's been pregnant or your woman that's been pregnant, there's a lot of steps. There's a lot of scans. There's a lot of things they have to do. It's anything outside of that normalness and attempting to cause the death of that child. Let's keep going. Conception means the fusion of human spermatozoon with a human ovum. Pretty self-explanatory. Department means the Mississippi Department of Health. Gestation means the time that has elapsed since the first day of the woman's last menstrual period. Again, that's gestation period. Gestation age or probable gestation age means the age of the unborn human being as calculated from the first day of the last menstrual period of a pregnant woman. Pretty self-explanatory. Human being means the individual member of the species Homo sapiens from and after the point of conception. Severe fatal abnormality means a life-threatening physical condition that, in reasonable medical judgment, regardless of the provision of life-saving medical treatment, is incompatible with life outside the womb. So right there, they give you the definition of if the baby was going to die anyway outside of the womb, that is a situation, they give you that definition here. Major bodily function includes, but is not limited to, functions of the immune system, normal cell growth, and digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. All the things our body needs here. Medical emergency means a condition in which, on the basis of the physician's good faith clinical judgment, an abortion is necessary to preserve the life of a pregnant woman whose life is endangered by physical disorder, physical illness, or physical injury, including a life-endangering physical condition arising from the pregnancy itself, or when the continuation of the pregnancy will cause a serious risk of substantial or irreversible impairment of a major bodily function. So right here is the clause, health of the mother. A lot of people always hark on, there's certain things that they want to see in an abortion ban or an abortion limiting bill that should be a kind of step over. This is it. Health of the mother is one of the big ones, and they've talked about it already. This is now officially, and these are the reasons. Health of the mother is a definition of a medical emergency here. And last definition, physician or referring physician means a person licensed to practice medicine in the state of Mississippi. Next section here. Abortion limited to 15 weeks gestation, except in medical emergency and in cases of severe fatal abnormality. Except in medical emergency or in the case of severe fetal abnormality, a person shall not perform, induce, or attempt to perform or induce an abortion unless the physician or the referring physician has made a determination of the probable gestational age of the unborn human being and documented that gestational age in the maternal patient chart, and, if required, in a report to be filled with the department as set forth in paragraph C of this subsection. The determination of probable gestational age shall be made according to the standard medical practices and techniques used in the community. So let's break that down here real quick. They say you cannot perform an abortion essentially unless a doctor has determined the gestational age and that they document it. They have to make sure they document it, and it needs to be sent to the right department, which is the medical department where they refer to Mississippi State Department of Health. So that is right there saying that it is a requirement that before performing the abortion, the doctor needs to put down the gestational age. So therefore, they will say whether or not it's a legal or illegal abortion, so they can go back and look at it. Let's keep going. Except in medical emergency or in case of severe fatal abnormality, a person shall not intentionally or knowingly perform, induce, or attempt to perform an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. So again, right there, can't perform an abortion past 15 weeks. No doctor is allowed to do that under this bill. C. In every case in which a physician performs or induces an abortion of an unborn being whose gestational age is greater than 15 weeks, the physician shall, within 15 days of the abortion, cause to be filled with the department on a form supplied by the department, a report containing the following information: date the abortion was performed, specific method of the abortion used, the probable gestational age of the unborn human being, and the method used to accumulate gestational age, a statement declaring that the abortion was necessary to preserve the life or physical health of the maternal patient, specific medical indications supporting the abortion, and probable health consequences of abortion and specific abortion method used. So again, a lot of words there. Let's break it down. If the doctor has to perform an abortion. And every time the doctor does perform an abortion, within 15 days, they need to fill out a form with the date, what the method they used to perform the abortion, how old that baby was at the time of the abortion, how many weeks. They need to write down a written statement why it was necessary to, what the risk of the woman was, the risk of the mother was that they needed to perform it. The medical indications that backed up this belief that the woman was at risk. And what's the future? What's the future plan of taking care of this woman after she had to have an abortion? Let's keep going. The physician shall sign the form as his or her attestation under oath that the information stated thereon is true and correct to the best of his or her knowledge. So again, putting it down, this is all on the doctor. That's what you will get when you read the end of this bill. The doctor is putting everything at risk by performing an abortion here, if it's not within 15 weeks. Not within the 15 weeks. Let's keep going. Reports required and submitted under subsection 4 of this section shall not contain the name of the maternal patient upon whom the abortion was performed or any other information or identifiers that would make it possible to identify in any manner under any circumstances a woman who obtained or sought to obtain an abortion. This is one of the most important parts that you need to read about this bill, because one of the things that people always say about Roe v. Wade, and they're saying it right now, is the fact that it basically created privacy in medical practice. And they always say that any sort of abortion ban bill always violates that. They're talking about it with the Mississippi bill. This right here, what is this? It's section D under A. It's A, B, it's a subsection. I don't know what page it's on, but it's section D. It starts with reports. This is saying that you cannot identify the woman in any way, shape, or form that is getting an abortion or is seeking to get an abortion. Not just if it gets performed, but even if one is inquiring about when it gets cold feet and backs up, you cannot say that this woman did it. That is important. If you are someone that is for this bill, that is something that you can say, like, hey, no, you're wrong about that, because they will bring that up. Roe versus Wade created so much privacy, and Casey backed it up. And you could say, well, this bill backs them up too, because they still cannot let the cat out of the bag of the woman's name or any indicator of who they are. They really split any indicator, information, or identifiers to make it possible to identify in any manner, under any circumstance, a woman who obtained or sought to obtain an abortion. Very clear language there. Privacy is protected under this bill. Let's keep going. Reporting forms. The department shall create the forms required by this section within 30 days after the effective date of this act. No provision of this section requiring the reporting of information on forms published by the department shall be applicable until 10 days after the requisite forms have been made available or the effective date of this act, whichever is later. So essentially, you don't have to fill out forms until about 40 days after this act happens by punishment, because they have within 30 days to do it. And then they have 10 days to be made available. If we know anything about government, this is going to take them the full 30 days to get it out. So essentially, if this act gets approved by the Supreme Court, they have another 40 days to provide it, essentially. Let's keep going. Professional sanctions and civil penalties. A physician who intentionally or knowingly violates the prohibition in subsection 4 of this section commits an act of unprofessional conduct, and his or her license to practice medicine in the state of Mississippi shall be suspended or revoked pursuant to action by the Mississippi State Board of Medical Licensure. So again, right off the bat, the physician gets penalized with their license here, suspended or revoked right away. Let's keep going. A physician who knowingly or intentionally delivers to the department any report required by subsection 4C of this section and known to him or her to be false shall be subject to a civil penalty or fine up to $500 or per violation imposed by the department. So these are the sanctions and civil penalties of this bill. There is nothing going after the woman that seeks or gets the abortion. There is everything going after the doctor. And there's no jail time or anything. They're not calling them murderers. They're not saying that it's murder. They're not putting them in jail. They lose their license to practice medicine, which is big because that's their livelihood. So that's a huge hit. And if they lie about it, they're probably going to lose their license, and they're going to be fined $500 per violation into the department. So it could be pretty lengthy if they lie a bunch of times, but that is the penalty here. There is nothing on the woman. Women can still go get and seek abortions whenever they want. If the physician's willing to perform it, they're putting their license out on the line if they do it past 15 weeks. And if they lie about it, it could be even worse. They could pay a lot of money, but there's no jail time. There's nothing saying that they're murdering a kid. There's no felony. It is civil penalties and sanctions. So again, this isn't such a big felony, misdemeanor, jail time type of thing. It is going after the doctors. So the doctors, if there's these strong doctors who feel so strong about performing abortions, go for it. You could still do it. You're just doing it under your own risk. Let's keep going. Additional enforcement. The Attorney General have the authority to bring an action in law or equity to enforce the provisions of this section on behalf of the Director of the Mississippi State Department of Health or the Mississippi State Board of Medical Licensure. The Mississippi State Board of Medical Licensure shall also have the authority to bring such action of its own behalf. So again, those other two people, your Attorney General and the State Board of Medical Licensure, can also go after any physician that's doing this. Again, no jail time, civil penalties, stripped of licensure. Still sucks. A lot of money could be had if they lie. Your livelihood could be fucked. But again, it's not as bad as people make it out to be in terms of the penalties. And the woman still walks away scot-free. They get the mental issues of getting an abortion. They get all that, but they can still go get the abortion. They can still go seek the abortion. There is no penalty for women at all under this bill. Let's keep going. Construction. Nothing in this section shall be construed as creating or recognizing a right to an abortion or as altering generally accepted medical standards. It is not the intention of this section to make lawful an abortion that is otherwise unlawful. An abortion that complies with this section but violates any other state law is unlawful. An abortion that complies with another state law but violates this section is unlawful. Severability. It is the intent of the legislature that every provision of this section shall operate with an equal force and shall be severable, one form or the other, and that. In the event that any provision of this section shall be held invalid or unenforceable by the court of competent jurisdiction, said provision shall be deemed severable and the remaining provisions of this act deemed fully enforceable. So what this is here and what this whole section is here is saying that if any parts of this bill are found to be unconstitutional, that part alone will be the part that is now stopped. The rest of the things in this bill will continue to be law. So it's a smart thing to put in if you're making a bill that has multiple sections, right? Because if they find that you cannot strip a doctor of his license, and that's a big unconstitutional thing. But that part will be struck. So a doctor can perform the abortion, they can't get their license stripped. But that second part where there could be a civil penalty for lying about it, that still holds up. That doesn't null and void the whole bill. So let's keep going and reading about more of the severability here. In the event that any provisions of this section shall be held invalid or unenforceable by the court of a competent jurisdiction, sections 4141, 131 through 4141, 145 shall remain in effect. I don't know exactly what sections those are, but they're there. If some or all the provisions of this section are ever temporarily or permanently restrained or enjoined by judicial order, all other provisions of Mississippi law regulating or restricting abortion shall be enforced as though the restrained or enjoined provisions had not been adopted. However, whenever the temporary permanent restraining order or injunction is stayed or dissolved or otherwise ceases to have effect, the provisions of this section shall have full force and effect. So again, whatever is taken, if there is ever anything by a court done to this law, any other law pertaining to abortions will still be in effect. And if that injunction ever stops, then this law comes back to being the law of the land. Let's keep going here. Mindful Levitt versus Jane regarding the context of determining the severability of a state section of law regulating abortion. The United States Supreme Court held that an explicit statement of legislative intent is controlling. Accordingly, it is the intent of the legislature that every provision, section, subsection, paragraph, sentence, clause, phrase, or word in this section and every applicable of the provisions of this section is severable from each other. If any application of any provision of this section to any person, group of persons, or circumstances is found by a competent court to be invalid, the remaining application of that provision to all other persons and circumstances shall be severed and may not be affected. All constitutionality valid applications of this section shall be severed from any applications that a court finds to be invalid, leaving the valid applications in force. Because it is the legislation's intent and priority that the valid applications be allowed to stand alone. Even if the reviewing court finds a provision of this statute to impose an undue burden in a large or substantial fraction of relevant cases, the applications do not represent an undue burden shall be severed from the remaining provisions and shall remain in force, and shall be treated as if the legislation had enacted a section limited to the person's group or persons or circumstances for which the section's application does not present an undue burden. The legislature further declares that it would have passed this section and each provision, section, subsection, paragraph, sentence, clause, phrase, or word, all constitutional applications of the section without regard to the fact that any provision, section, subsection, paragraph, sentence, clause, phrase, or word, or application of this section were to be declared unconstitutional or to represent an undue burden. Let me break that down in layman's terms. Anything that's found unconstitutional by a court is on its own. Everything else remains. That's all this means. And they have to put it in there and put it in a lot of words so that it is clear as day with severability. That's all it is. If they strike down one part, the rest of it still counts. If it happens in one case where they strike down one part in one case, it does not affect all other cases. The bill is still in full force there. Each court needs to find each part of this wrong if it's in a specific court case. That's what they're saying. Let's keep going. If this section is found by any competent court to be invalid or to impose an undue burden as applied to any person, group of persons, or circumstances, the prohibition shall apply to that person or group of persons or circumstances on the earliest date on which this section can be constitutionally applied. There's only a few more things here to go, guys. Stay with me. If any provisions of this section are found by a competent court to be unconstitutionally vague, then the applications of the provision that do not present constitutional vagueness problems shall be severed and remain in force. Again, more of the things. If something is found wrong, the rest of it applies. That's gone. That's it. Last section before it basically says this is a law. Right of intervention. The legislation, through one or more sponsors of this act, duly appointed by resolution of their respective chamber, may intervene as a matter of right in any case in which a constitutionality of this section is challenged. The governor may also intervene as a matter of right in any case in which a constitutionality of this section is challenged. So basically, if it's challenged, it can be brought back to the legislature to be heard again. And the governor can also intervene and have it, have it changed there. So last part, section 2, which is always included, this act shall take effect to be enforced from and after its passage. So there we go. That is the full bill. How long did that take me to read? It took me under 40 minutes to read that whole bill out loud with me opining on certain parts. So what do I take away from this bill? The brutality of abortion, obviously, that, I talked about the 15 weeks versus the 12 in other countries, one-on-ones. But one of the big things that I take away here from this is when you read the bill, they're hard on abortion. They don't want abortion in Mississippi. But one thing that you see here, Mississippi is a pretty conservative state. That is a conservative house. They're right-leaning. They are compromising in a way. 15 weeks is 15 weeks more than they actually want. If it was up to them, they would flat out ban abortion, flat out. So 15 weeks is them coming to the table and compromising. What you see is the left not compromising on this. They want abortion open, period. Women's rights, my body, my choice. Fuck you. You don't have a say, period. That's it. No compromise. These are a bunch of people who are probably pretty religious in their thinking, and they don't want abortion at all, but they are willing to do 15 weeks and go to viability. They're going with science here. People are like, we both, believe the science, follow the science. They're going with the known science currently on this. So there's that, number one. Number two, the whole onus is on the physician here. The woman, like I said, is not on the hook for anything that's getting an abortion here, besides the mental issues that comes from having an abortion and maybe the physical issues that come from having an abortion. Outside of that, they are not on the hook for anything here. This is all on the physician. And number three, there's nothing criminal about that. There is no criminality in performing an abortion past 15 weeks. You might lose your license. You might get some penalties to pay fines, but you're not a criminal. You're not going to jail. So there's that. The fine, the issue is severe because you lose your license, but it's not severe in the sense where you're going to go to federal prison or state prison, or you're going to go to jail for it. So in terms of, I guess, levels here, It's not as bad as they make it out to be. What else did I take away here? One of the things that I went away from it, I was waiting the whole time for the clause where rape and incest would also be a qualified exception. Nowhere here did it say rape and incest is a qualified exception. I take an issue with that personally. They covered one of three of my exceptions personally. Health of the mother is one, and always. Rape, I also believe, if obviously, I guess it's going to suck because the way I put it, a lot of women aren't going to agree. But unfortunately, the onus will be on the woman to go and get a rape kit done. And we're pretty good with those. We can figure out if a woman has been raped through a rape kit. I don't know what goes into it, what they do with the rape kit, but they can figure it out pretty easily. Most women that get raped do not want to relive that. I understand that. It's mental fucking trauma. They do not want to relive that trauma. They do not want to, they try to block it out. A lot of times they don't want to even talk about it until it becomes too much to bear. I get it. But rape is one of those where I am unequivocally about, okay, if you got raped and now you're pregnant, you don't want your rapist fucking baby. Okay, go for it. I get that. I completely get that. You were a victim of a heinous crime. No reason for you to have to carry it. I get that. And incest is fucking gross. And it produces, we know the negative things that can happen for a kid that's born out of incest. That is a terrible way to live. I get that. Incest, another one. So that's the thing to me. If I'm voting on this bill, I'm shooting it down in the Supreme Court. And I'm telling Mississippi to go back and put those provisions and represent it and repass it. And then I will vote for it. That is where I'm at with this bill. And the last thing I took away, they protect women's privacy. And this again, don't let anyone ever tell you in this bill that, Roe versus Wade is so big on privacy. This bill covers it. So tell them to fuck off when it comes to that. But if you're coming to me with this bill, I agree with, I want to say 80% of the bill, because those two would be 10% each, 20% together. Those would be two things that I need to see in the bill if I wanted to pass this bill. Overall, it's a well-written bill. It's a bill that really hits on the emotion. It talks about the baby pretty well and where it's at. It hits on the emotion of brutally describing an abortion procedure that is inhumane. It talks about gestation. It talks about all that stuff. It's well written. It's well cited with the way they wrote it. I would absolutely need to see those two provisions put in here before me as a Supreme Court justice could actually pass this. I could certainly see Justice Roberts not voting for this, and I can certainly see Justice Kavanaugh switching sides. I can. And I think in a surprise, you might see Amy Coney Barrett waiver, because that's a big thing. Getting raped is no joke. It's a felony for a reason. It's terrible. And, I guess, some people might not agree with me, but I guess that's where I'm a little bit of a progressive. Forcing a woman to carry a baby after a rape, that is inhumane. And that is terrible to do. So that's where I am in this bill. I read the bill in full to you. I hope a lot of people listen to this podcast, because we need to start reading these bills. Whenever these big things come up, we let the narrative get shaped by people that either know what's in it and don't care, don't know what's in it and just make a statement because they need to be on a political side, regardless. But the biggest thing to do is go look up these bills. Listen, if they're fucking 100 pages, 50 pages, even 20 pages, whatever, don't read it. Skim it. Look for bullet points. Do a find and see certain words you want to see. See if they're in there. Do those things. If you want to sit down and read it, sit down and read it. If it's a long bill, I don't blame you if you don't read it. They make those bills long intentionally, but we have things to do. A bill like this that I want to say is maybe 4 pages. A bill like the parental rights and education, quote unquote, don't say gay bill in Florida, was 7 pages with a 2.5-page abstract, 1.5-page abstract. I mean, these are not hard bills to read. They're not hard bills to take in. They don't take very long. I talked about it on the side and it took me under 40 minutes. For you to just sit down and read it, this is maybe, if you got to sit there, maybe think about some of the shit that they're talking about because it's legalese, maybe 5-10 minutes at most, And that's if you're a slow reader. So please go find it. I'm going to include the link to find this bill so everyone can read it so they don't have to listen to me. But man, do your homework. I know Brian Stelter hates that, but this is one of the things you could do. And we all know lawyers. We all know somebody who's a lawyer. If you struggle with any of the definitions in here, you can Google it. Google has great definitions. You can go find that. If you don't like Google, do DuckDuckGo. If you don't like DuckDuckGo, use the Brave operator, what you call it, search engine, whatever it is. Do that. The Brave browser. Do that. Do whatever it is you want to do. But please, be on both sides, be informed about this, because I know there's a lot of people on the right like me that are just siding with it because it's an abortion ban bill and 15 weeks doesn't seem so bad. But there's a lot of people like me that are like, wait a minute, you're not going to let a chick that got raped get an abortion? That's not going to be in here. You're not going to let people that performed incest get it. There's some things in here that make me not jive with this bill, and that's it. And I have my positions where I stand, and I don't really waver unless I'm given a true reason to waver. And to me, those are two things that are pretty concrete and bedrock with me. So, all right, everyone. I really hope that that helped out a little. I hope that was a little educational. I hope it wasn't too boring. I tried to explain out in the best ways that I can, the layman's terms of it. If I missed some definitions, if anyone's a lawyer out there that listens, please tell me if I was wrong about something. Educate me. I want to be educated on certain shit, especially things like this, because I plan on, if there's bills that are big and they're readable and they're not 7 million pages, I'll do this again because I think this is informative. I think it's good. I think people either don't know they can do this or don't want to take the time. And sometimes it's easier to just listen to it. So everybody, I really appreciate you for listening. As always, like, share, follow, subscribe, rate 5 stars on Spotify and iTunes, spread this word of mouth, and find us on social media, the Alex Questa Show, Twitter, Facebook, Instagram. Everyone, thanks again for listening. Hopefully this was educational, like I said, and I'll be back tomorrow. See you later, everybody.